We continue to read the divorce case. The 4 months long marriage which ended in divorce between Mr. and Mrs. Hall, and where Mrs. Hall applied for half the value of the house, applied for spousal maintenance, and applied for a child which he had with another man after 4 months of marriage. We continue. Summary of submissions on behalf of Mrs. Hall. Counsel argued that the defendant, Mr. Hall, was maintaining both Mrs. Hall and her daughter up to the date of separation. However, he then ceased his financial support, though at the time of the marriage, Mr. Hall was aware that Mrs. Hall's earnings had been adversely impacted by her personal injuries she suffered back in 2014. All the way back, years back in 2014. He was supposed to maintain her because of that injury. I guess long before he even knew her or met her. He also submitted that she also made contributions from her hairdressing business towards the family home. But Mrs. Hall was unable to stand for more than 15 to 20 minutes at a time without breaks, and so her income had declined. Mr. Hall, according to counsel, has a greater earning power, but he has not made full disclosure of his earnings. So Mrs. Hall's lawyers are accusing Mr. Hall. Now, Mrs. Hall is accusing Mr. Hall through her lawyers of hiding some of his income, some of his money. That's a usual situation during these divorces, I see. Well, we continue. He asserted that Biscuit, which the defendant started in 2006 to do a private financial accounting work, is an active business at the company's office, and it provides more than $450,000 monthly to him. He conceded, however, that the extent of this net income is uncertain. Counsel, that's Mrs. Hall's attorney, profited that Mr. Hall obtained a maintenance order for the child's biological, that Mrs. Hall obtained a maintenance order for the child's biological father to pay $34,500 monthly. But the father had been in arrears, and Mr. Hall was aware of this. Further, that Mr. Hall paid for the child's private tuition for a while, and she benefited from whatever food he brought into the home during the marriage. So what the lawyer seems to be trying to do is to convince the court that Mr. Hall accepted the child as a child of the family and should therefore pay maintenance to this child. So I hope you're looking into these matters and learning. I'm learning a lot. These are the kind of tactics that the divorce lawyers apply in these cases. We continue. He relied on Section 6 of the Maintenance Act to advance the position that the defendant has a legal obligation to maintain Mrs. Hall upon the termination of cohabitation. So you see, it's 4 months of marriage. They don't consider that. It seems as if even though it's 4 months of marriage, I mean, this thing is ruthless. My gosh. 4 months of marriage. And they're trying to convince the court to hand over half the house, pay maintenance, child maintenance for another man's child. They don't play around. I mean, this thing is brutal and ruthless, man. Anyway, we continue. He also highlighted Section 9 of the Maintenance Act to support his argument that the defendant has assumed financial responsibility for the child, and therefore it would be reasonable for the court to grant a maintenance order for the child. Whoa. Counsel also argued that the claimant, Mrs. Hall, relied on assistance from her mother who resides in the United States of America, but that the mother had stopped working. He contended that the evidence showed that the claimant, Mrs. Hall, and the minor, that's a child, are in need of financial assistance and sought to distinguish the case at bar from what took place in Antoinette Nancy West Lambert versus Peter Laham versus Peter Laham 2017, where the child was not deemed in need of maintenance. So the lawyer draws on that case. He posited, that's Mrs. Hall's lawyer, posited that the marriage was genuine and not void, and that the parties had only separated and no decree absolute had been granted. He relied on the case of Carol Stewart versus Larison Stewart 2013 to support the position that even if the court rules that the statutory 50-50 rule does not apply, it is not the law that a short marriage equates to no share being allotted to the claimant, but that the court is to come to a fair and equitable appointment. We will look in our next video at the summary of submissions on behalf of the defendant, Mr. Hall.